two judgments reaching a particular outcome and the other two a different one. We do have a majority judgment which constitutes the judgment of the court. The summary I'm about to read is limited to the main findings and conclusions reached in each judgment. This application is the sequel to Economic Freedom Fighters v. Speaker of the National Assembly, a judgment of this court which was delivered on 31 March 2016. In that matter, this court held that the President had failed to uphold, defend, and respect the Constitution. This failure was manifested, the court concluded, from the disregard for the remedial action taken against him by the public protector. In the same judgment, and with regard to the National Assembly, the court held, open quote, on a proper construction of its constitutional obligations, the National Assembly was duty-bound to hold the President accountable by facilitating and ensuring compliance with the decision of the public protector, close quote. A resolution passed by the National Assembly and which exonerated the President from liability was declared inconsistent with the Constitution and was set aside. This was in addition to other orders issued by the court which are not relevant for present purposes. On 30 March 2017, the Economic Freedom Fighters, the United Democratic Movement, and the Congress of the People instituted the current application in this court. They sought direct access on the ground that the issues raised fall within the exclusive jurisdiction of this court. On the merits, they sought an order declaring that the Assembly has failed to fulfill two obligations arising from Section 89 of the Constitution. They contended that the section obliged the Assembly to adopt rules that govern the removal of a president from office. They argued that since the current rules do not regulate such process, the Assembly has failed to discharge this obligation. Furthermore, they contended that the Assembly has failed to hold the President to account, following the findings of the Public Protector and this court in its judgment. They argued that the President has committed a serious violation of the Constitution and the law. In addition, they contended that he has also committed a serious misconduct contemplated in Section 89, Sub 1 of the Constitution. The application was opposed by the Speaker and the President. With regard to the issue whether the Assembly has failed to make rules regulating the removal of the President from office, the respondents argued that the current rules of the Assembly provide for the removal of the President under Section 89 of the Constitution. Reference was made to Rule 85. Regarding the claim that the Assembly has failed to hold the President to account, the respondents argued that the President was held accountable in a number of ways. They mentioned examples including question and answer sessions, motions of no confidence, and other motions whose purpose was to remove the President from office. They pointed out that all these motions failed because they lacked the necessary support from the majority within members of the Assembly. Closer to the hearing of the matter in September, the Democratic Alliance sought and was granted leave to join the proceedings as an intervening party. It is not in dispute that the issues raised in this matter fall within the exclusive jurisdiction of this court. The main complaint on the merits relates to the Assembly's failure to fulfill its constitutional obligations. In terms of Section 167, Sub 4 of the Constitution, only this court may determine whether Parliament has failed to fulfill a constitutional obligation. it follows that permission to bring the case directly to this court must be granted. The question whether the Assembly failed to make rules envisaged in Section 89 of the Constitution requires us to interpret that provision so as to establish whether it imposes the obligation the applicants claim the Assembly has not fulfilled. Section 89 provides, the National Assembly, by a resolution adopted with a supporting vote of at least 2/3 of its members, may remove the President from office only on the grounds of A, a serious violation of the Constitution or the law, B, serious misconduct, or C, inability to perform the functions of office. In a judgment prepared by me, concurred in by my colleagues Cameron, Froneman, K3 Sitilwane, Kolapen, Mhlantla, and Teron, we observe that this provision empowers the Assembly alone to remove the President from office. We conclude that the Assembly may remove the President from office only if one of the grounds listed in the section is established. The section does not define the meaning of each ground. It does not tell us what is meant by a serious violation of the Constitution or the law, nor does it shed light on what a serious misconduct is. What emerges from a closer reading of the entire section is that the drafters of the Constitution left the details on these grounds to the Assembly to spell out. In our view, these details should be set out in the relevant rules. It is those rules which must state what the Assembly considers to constitute a serious violation of the Constitution or the law and serious misconduct. Without such rules, we conclude that it is impossible for Section 89 to be implemented. This brings us to the question whether, in the present form, the rules of the Assembly provide for the removal of the President in terms of Section 89. The respondents asserted that Rule 85 regulates the President's removal from office. The rule is not relevant. It prohibits members of the Assembly from impugning the integrity and dignity of other members during debates in the Assembly. This prohibition also protects the President during debates. Reference was also made to Rule 253, which provides for the establishment of ad hoc committees. It was argued that an ad hoc committee may be established to investigate and recommend to the Assembly on whether there was a breach of Section 89 sub 1, which was serious enough to warrant removal of the President from office. We hold that the ad hoc committee system is not suited to the requirements of Section 89. It does not have a set procedure for the committee to follow when it carries out its task. In terms of Rule 255, an ad hoc committee decides a matter before it by means of a consensus. A removal of the President from office may easily be frustrated in the ad hoc committee. Accordingly, we conclude that, properly interpreted, Section 89 implicitly imposes an obligation on the Assembly to make rules specially tailored for the removal of the President from office. By omitting to include such rules in its rules, the Assembly has failed to fulfill this obligation. The next question is whether the Assembly failed to hold the President accountable. The power to act in terms of Section 89 is conferred upon the Assembly alone. It is the Assembly which must determine first and foremost whether any of the grounds for the President's removal from office has been established. If such grounds exist, then the process envisaged in the section must be followed. For a removal to succeed, it must be supported by a 2/3 majority of the members of the Assembly. With regard to this question, the applicants have argued that since delivery of judgment by this court on 31 March 2016, the Assembly has failed to act against the President in terms of Section 89 of the Constitution. They contended that this court has held that the President had violated the Constitution. They argued that despite the seriousness of this violation, the Assembly has done nothing to hold the President to account. The determination of this part of the claim required this court to examine the steps taken to hold the President accountable after delivery of the judgment of 31 March 2016. It is not true that the Assembly has done nothing. As the respondents pointed out, question and answer sessions were held in the Assembly, motions of no confidence were tabled and debated and voted on. But these motions failed because they did not obtain the necessary support from within members. However, the crucial issue in our view is whether appropriate action contemplated in Section 89 was taken by the Assembly. We hold that the Assembly may not claim to have complied with Section 89 if the action it has taken was not the one envisaged in that section. The question and answer sessions and motion of no confidence are not action contemplated in Section 89. Motions of no confidence are tabled under Section 102 of the Constitution, which requires a simple majority for the motion to succeed, and it is not necessary to base such a motion on any ground. While the President may be removed from office by means of a motion of no confidence, such removal may only be based on Section 102 and not Section 89. What is left for consideration is the motion for the President's removal, which was tabled by the Leader of the Opposition on 31 March 2016. That motion was debated and voted on by members of the Assembly on 5 April 2016. A majority of those members voted against it. Consequently, the motion was defeated. What needs to be decided, in our view, is whether the processing of that very motion complied with the requirements of Section 89. If it did, that would be the end of the matter, because the section does not oblige the Assembly to remove the President from office even where the listed grounds are established. In our view, the processing of that motion did not comply with Section 89. The Assembly simply debated and voted on the motion. It did not satisfy itself that the violation of the Constitution on which the motion was based was of the kind contemplated in the section. Therefore, we conclude that the Assembly did not hold the President to account as was required by Section 89. Section 237 of the Constitution obliged the Assembly to fulfill its obligations diligently and without delay. As outlined here, the Assembly has failed to perform two of its obligations without delay. In a separate judgment prepared by the Deputy Chief Justice, Zondo, concurred in by the Chief Justice, Madlanga J. and Zondi A.J., he concludes that the Assembly had put in place a mechanism that could be used effectively for the removal of the President from office in terms of Section 89. He holds that an ad hoc committee may be established to undertake the process envisaged in the section. Therefore, he concludes that the Assembly has fulfilled the obligation to make rules regulating the removal of the President from office under Section 89. With regard to the question whether the Assembly has failed to hold the President accountable, the Deputy Chief Justice concludes that this was done in terms of the motion of 31 March 2016. He reasons that since this court had already declared that the President had violated the Constitution, there was no need for the Assembly to satisfy itself that the President had committed a serious violation. He concludes that in the present circumstances, there was nothing to be investigated by the Assembly. All that was left was for the motion to be debated and voted on. According to him, the motion was processed in compliance with the relevant section. In his judgment, the Chief Justice concurs in the judgment of the Deputy Chief Justice With regard to the majority judgment, the Chief Justice holds for various reasons that the approach by the majority trenches upon the doctrine of, sorry, the Chief Justice has just handed over to me a document that I had just summarized. He would like it to be read into the record. In his concurrent judgment, the Chief Justice characterizes the majority judgment as a textbook case of judicial overreach, a constitutionally impermissible intrusion by the judiciary into the exclusive domain of Parliament. He holds that it is irreconcilable with the dictates of separation of powers and context-sensitive realities to prescribe an inquiry to the National Assembly as the only mechanism for determining the existence of a ground of impeachment, and that it is just as insensitive to this doctrine to hold that an impeachment ground must always be determined before the debate and voting on a motion of impeachment could take place, and to direct the Assembly to make rules that would effectively regulate the process as so prescribed. This, he says, is resoundingly negated by the deposition of most of applicants to the effect that seriousness of the constitutional violation in relation to Gandla is self-evident and well-established, and their acceptance that existing mechanisms could be used to hold the president accountable for Gandla. Without any inquiry, these parties represented in the Assembly were able to determine the existence of an impeachment ground. He concludes in this regard that it is constitutionally impermissible for a court to order Parliament to do what it is already doing in circumstances where it has not identified any deficiency with that parliamentary process. The second judgment's inability or failure to confront squarely the issues pertinently raised by the first and this judgment in relation to the very purpose of an inquiry and its alleged indispensability is, in the view of the centrality of the inquiry to the declaratory order, most concerning. An inquiry has a clear purpose to serve. It is to unearth the unknown or ascertain the unclear. He contends that it is a purposeless exercise to hold an inquiry, even if the already available documented or otherwise recorded information could be sufficient for the purpose of determining the existence of a ground of impeachment. There is, in his view, a striking similarity between determination of the existence of a ground for impeachment and of a ground relied on for a desired court outcome. In High Court opposed motion proceedings, parties file affidavits and annex supporting documents to help the court resolve even highly complex legal or constitutional issues. Similarly, this court exercising its direct access or exclusive jurisdiction has routinely resolved very intricate constitutional issues. This mechanism has been most effectively and impressively employed without the need to resort to any inquiry or investigation before argument in court and the decision. Courts are themselves, therefore, not required to always determine grounds for the order sought or resolve complex constitutional issues only through a process of calling witnesses to testify and have their versions tested. And they do not ordinarily have to predetermine the existence of any ground before argument or a decision on the issue presented for determination. By parity of reasoning, it must be constitutionally permissible and practicable for another arm of the state to properly determine the existence of a ground of impeachment either through an inquiry or sheer reliance on the abundance of documented or otherwise recorded evidential material, in brackets, motion proceedings equivalent, readily available to it. For these reasons, Mogoeng CJ holds the view that the majority has imposed its preference on Parliament in circumstances where separation of powers forbade it. In his judgment, Froneman J. concurs in the majority judgment and disagrees that that judgment breaches the principle of separation of powers. In the result, the following order is made. 1. This court has exclusive jurisdiction to hear the application. 2. The failure by the National Assembly to make rules regulating removal of a president in terms of Section 89, Sub 1 of the Constitution constitutes a violation of this section and is invalid. 3. The National Assembly must comply with Section 237 of the Constitution and make rules referred to in paragraph 2 without delay. 4. The failure by the National Assembly to determine whether the President has breached Section 89 Sub 1A or B of the Constitution is inconsistent with this section and Section 42(3) of the Constitution. 5. The National Assembly must comply with Section 237 of the Constitution and fulfill the obligation referred to in paragraph 4 without delay. 6. The National Assembly and the President must pay costs of the application jointly and severally, including costs of two counsel where applicable. I hand down the judgment.
Thank you.